All right. The next 50 minutes or so, maybe an hour, Mark Barnes and I are going to talk about the court remedies in a workers' compensation claim. How do you utilize them? When do you utilize them? Why do you utilize those remedies? And I hope at the conclusion of this talk, you will realize that those tools that Ohio gives employers, the tools to file appeals to trial courts in Ohio, are invaluable to managing and eventually closing down and settling claims that justify that action. So let's recap the claims that we have today. First of all, Archie. And we're going to recap them in the sense of putting issues before you and what can be done with those issues. Archie, as you've heard, he was awarded statutory PTD. He got back to work, light duty, in June. And again, I'm taking liberties on these dates. In August, he has this surgery, and they put in a brand new prosthesis. Very innovative prosthesis, and he had a tremendous result from the surgery. He's determined to be able to return to work January 10th of this year, but he just chooses not to return to work, and he files a motion for temporary total disability. That's Archie, and that's where we are with him. Okay, let's go to Florence. She was terminated for the excessive use of prescription drugs. The staff hearing officer allowed the claim for a lumbar strain, and the Industrial Commission refused the employer's last-ditch appeal, as they often do, and the employer received that refusal order January 10th of this year. There is also pending in the agency a motion filed by Florence to additionally allow the claim for a substantial aggravation of a pre-existing generalized anxiety disorder, and she's also requested a payment of temporary total disability compensation since the injury. And that brings us to Fred. Fred's claim is allowed for the substantial aggravation of the pre-existing cervical degenerative disc disease. TT's awarded. Northwest Ohio Trash, because they came to our seminar, filed a motion to abate that claim and requested a finding that the degenerative cervical condition had reached pre-injury status. Rob Soll talked about that. And a hearing is scheduled next week before a district hearing officer. That's where we are. So let's talk about what tools are available. And if you haven't noticed yet, Mark's not going to just stand here and say nothing. This is sort of a tag team type of situation, and I think it's...
Tag.
You're up.
All right. Yeah, we're going to tag team you. He's John Sema, and I'm Dwayne Johnson, The Rock.
Who's John Sema?
You're showing your age, man. So I was kind of reflecting back on what, is my mic on? Can you hear me? Am I good? Reflecting back on what Janelle said about saving time in the afternoon for the long-winded folk. And I realized that the afternoon team is comprised of the talkers. We are the talkers. And I was thinking, why is that? Why do we tend to be a little bit more long-winded? Well, we're talking to you about being in court. In court, we're not as constrained as we are in the Industrial Commission. If you've been to commission hearings, you know, you get 15 minutes. That means each side has 7.5 minutes to make a presentation. If you have a witness, then you probably have 4.5 minutes. So you have to be concise. We don't have those constraints on us. When we're in court, we can talk as long as we want, to our own detriment, of course, because the jury is only going to listen to you but for so long. But you'll see we used I like to talk about the theme. I was watching all the presentations. You see all the stars and planets and all of that stuff. We used a planetary scheme here because sometimes the Industrial Commission and courtrooms and things of that nature are so foreign, it's like being in an alternate universe. So we decided to use this universe theme, and you'll kind of see that throughout the presentation. So, how do you get cases into court? This is not magic, okay? It doesn't just, you just don't say, hey, I'm going to court. There is a method to the madness here, and that's what we're going to talk about. You basically have two general places that you can go. We're going to explain them because some people look at them as one and the same. They don't really understand the difference. Two journeys. One, the 10th District Court of Appeals in Franklin County, Ohio. That's in Columbus, where the state capital is. That's where you go if you've got a mandamus action. There's only one place. You don't go anywhere else, and we'll talk about that. But if you've got a mandamus action, you're going to that courthouse right there on High Street in Columbus. If you have a trial in a common pleas court, this is a map of Ohio. Greg corrected me. I thought there were 90-some counties. He said there are 88 counties in Ohio. And we put courthouses across the grid here to kind of show you visually what you're looking at here, but not covering every single county. That's where you are if you're in a trial court. So depending on where you have your business and where the injury occurred, that will dictate which one of these 88 counties you're going to have your trial. And that makes a difference because if you've been in the commission, you kind of know the players. If you tend to have claims in Toledo, you know your hearing officers at the district hearing officer level are Dave McGill and Lynn Nolte and Karen Asbury. You know their orientation, okay? You kind of know their habits, how they're going to decide. But once you get into this situation, it can be a bit of a crapshoot. Each courthouse has its own set of local rules that you have to follow. Each courthouse has sometimes several judges. In Lucas County, we've got a number of judges. Out in Defiance, you have one. So you don't always know what you're going to get, and this is the landscape that you're playing with then. So, back to this question. How do cases end up in court? I talk to clients all the time, and when we have conversations about court, sometimes people will refer to the Industrial Commission as court. Well, when we were in court a month ago, and I'll have to correct them and say that's not court. The Industrial Commission is not a court. It is a state agency, okay? There is a huge difference. Companies that have presence in other states, Indiana, Michigan, they're probably familiar with a different kind of administrative procedure. And under that procedure, there may not be an avenue to the courthouse, okay? And maybe that accounts for why people see it as court. And maybe it's because in the Industrial Commission, you know, you're making a case, a presentation, and somebody's sitting there making a decision. That's a hearing officer, but it's not a judge, okay? So getting into court is a matter of what is the authority and the procedure. Everything falls down from our Ohio Constitution. That is the body of law that gives the authority to get into court, okay? Whether you're talking about an appeal from the Industrial Commission, Public Utilities Commission, Civil Rights Commission, okay? These are all your agencies, and whether or not you can get into court depends really on what the Constitution says and what the statutes say referring back to the Constitution, okay? Give me a little bit of history here so you kind of understand what we're talking about. So, in Article 4, it reads, a court of common pleas has the power to review proceedings of administrative officers and agencies only when granted by law. So inherently, under the Constitution, you can't just jump into court. It's got to be granted by law, and the Constitution is not that body of law. It gives you the ability to get into court. This case, decided in '83, stated it a little bit differently, but still the same concept. In the absence of constitutional or statutory authority, there is no inherent right to appeal from an order of an administrative agency. So we're talking about workers' compensation, okay? And there is a statute. And Greg's going to talk at length about that statute and the rights that arise out of that statute and the procedures that that statute prescribes. Some of you who may have some more familiarity with, how laws operate, how you get into court, generally speaking, there's something known as an Administrative Procedure Act. Okay? It is a separate statute in Ohio and in other states and federally. There are different Administrative Procedure Acts, and that's the mechanism by which you can get into court. It doesn't apply in workers' comp. Okay? The Administrative Procedure Act in Ohio specifically says, yes, the Industrial Commission and the Bureau of Workers' Compensation are agencies, but as far as the appeal rights and how to go beyond the agency proceedings, that is dictated by Revised Code 4123.512. That's what confers the jurisdiction on the trial courts. And if you recall what I said a little earlier, it's the common pleas courts. If you understand the court structure in Ohio, there are 3 levels. You've got your trial courts, that's the common pleas court. Then you have the courts of appeals, and ultimately on high, you've got the Supreme Court of Ohio. Okay? For administrative agencies and appeals from administrative agencies, it's to those common pleas courts. That's what the Ohio Constitution talks about. Mandamus is something different, and we will get into mandamus a little bit later as well. Mandamus is, it's not an appeal, and I'll talk to you about that. Mandamus is a remedy that's only available when you do not have a clear legal right. Now, clearly, under RC 4123.512, and Greg will tell you about it, it gives you that right. That is your clear legal right. It's spelled out in the statute what things can be appealed. But beyond what's spelled out in the statute, you don't have a right to an appeal. We can sum it up basically like this. I know I kind of said this before and I'm beating you over the head. There are 2 ways you go. Trial court, that's on issues that involve the right to participate. It's a weird kind of concept. Greg's going to explain it to you. Extended disability, even stranger. But I can break it down for you into simple terms. That's mandamus. Mandamus actions generally are in your courts of appeals, trial courts, your common pleas courts. Tag.
All right. 512. This is probably the most important tool in an employer's bag in attempting to manage and control certain claims that it finds itself with. And the reason it is because Ohio is one of maybe a handful of states. I'm not aware of another state that gives either a claimant or an employer the right to file an appeal to a trial court and to actually have a trial in front of a jury that proceeds as any other lawsuit. And that's a huge right. Most appeals, Michigan for example, the agency makes the determination, and the only appeal one has who is disappointed with the decision is to file an appeal on the record and to argue that the commission missed it or committed an error of law or didn't decide the facts correctly. It's on the record that has been decided in the agency and the evidence that was submitted to the agency. In Ohio, no. So, we have this tool. When can we use it? Every order of the Industrial Commission is not appealable under 512. The only orders that are appealable are those that go to the right to participate. So you have our claims today. You have the one claim that's been allowed for a lumbar strain. That's an allowance issue. It gives the claimant the right to participate. It's appealable to the trial court. Orders additionally allowing claims. We have a motion to include an additional allowance of a substantial aggravation of a pre-existing psychiatric condition with Florence. Regardless of how the commission decides, the losing party will have the right to appeal that decision to the trial court and, believe it or not, have a jury decide whether or not Florence is entitled to compensation for that pre-existing psychiatric condition. By and large, all other orders, we call them extent of disability orders, permanent partial disability, permanent total disability, medical bills, chiropractic treatment, wage loss compensation, temporary total disability compensation, issues of abandonment of employment. All of those issues you can never get to a trial court because they don't go to the right of the claimant to participate. They go to the extent of the participation. Now, it looks clean here, appealable orders of the commission, allowances and additional allowances, and that's true. Those are nothing to talk about. They're appealable. However, there are a few orders that are appealable that you wouldn't think would be. We've had cases where there was a subsequent accident, a subsequent injury, and the commission decides that that breaks the chain of causation and pretty much closes down the claim because everything afterwards is due to the subsequent non-industrial accident and not due to the original injury. That order is appealable. Why? Because it goes to the claimant's right to participate, because the order shuts down that participation for the claimant. The order on pre-injury status that Rob Soul talked about, if that commission takes that motion and grants the employer's motion and abates the claim for the pre-existing degenerative condition, finding it had reached pre-injury status, that's appealable. So it's not just allowances and additional allowances. Once in a while, you get a little strange order. And if the effect of that order is to limit and terminate the claimant's right to participate for allowed conditions, probably appealable. Everything else is not. Here's the beauty. Here's the beauty of a where does fraud? It's not appealable. It's not appealable. Although there might be a lot of fraud in some of the cases that are appealed, but that's for to learn during the discovery process. It's a de novo appeal. What does that mean? We do it all over again. The jury is not entitled to know what the Industrial Commission decided in the claim. Doesn't enter into it. In fact, if the jury learns of it, it may be cause for a mistrial. Prejudicial, what the Industrial Commission did. It's a brand new game, and our experience has been there is really no correlation between what the Industrial Commission decides in the claim and the eventual decision of a jury in a trial court somewhere in Ohio, believe it or not. Because those people sitting in a jury box, they look at this whole system and they look at workers' compensation differently than a hearing officer, a district hearing officer, a staff hearing officer who hears hundreds, if not thousands of these hearings in 15-minute intervals. One becomes numb after a while. Juries don't. Only issue The only issue for the jury is yes or no. Is the person entitled to participate? The jury doesn't decide how much money, the jury doesn't decide how much medical treatment, the jury doesn't decide if there's any permanent disability. The jury's sole function is to decide that one issue, right to participate. So, the jurisdiction, as Mark indicated, .512, we call them 512 appeals. That statute confers on the trial courts throughout Ohio jurisdiction to decide workers' compensation cases. Now, as you recall in one of our recaps, the employer, I think, received the IC refusal order January 10th or something. I did that intentionally because that employer, should it decide it makes sense to appeal that initial allowance of Florence's claim, that allowance of a lumbar sprain, I think it was, has 60 days from receipt of that IC refusal order. It's jurisdictional. If you blow it and you get it there the 61st day, it's done. The court has no jurisdiction. That is mandatory, and you got to have a calendar, and you have to count days. You file the appeal in the county where the injury occurred. So if you got a manufacturing facility over in Crawford County, that notice of appeal goes into Crawford County. Or where the exposure occurred if it's an occupational disease claim. So you say, well, maybe one of our employees was over in Indiana and they had some incident and had an injury. Where would you file that case? Well, the law says you would file that case in the county in which the contract of employment was entered into. And if there are no counties in Ohio, then the statute reverts back to the venue provisions of the civil rules, which means where the employer does business, where the plaintiff lives. So there's always proper venue in some county in Ohio. This is the beautiful. It's one of the reasons why I think this is the most important provision in Chapter 4123. Regardless of who wins in the commission, the plaintiff, the claimant, has the burden of going forward with the lawsuit and the burden of proof. So a claimant may have won throughout the commission, and if the employer appeals that to court, it's the employee's burden of proving the case. The employer doesn't need to prove anything. It needs to defend itself, but not to prove anything. Rules of civil procedure apply. Unlike the agency, we have rules in court. And most of the time, they work to the advantage of the employer, because lawyers have to do things on certain times. You have to answer discovery. You have to file motions and answers within certain deadlines. So there's a structure to it. And probably the most important aspect of a 512 appeal is that when it becomes trial day, the rules of evidence apply. And no longer can one lay down a medical report from Dr. Smith and say, there's my medical evidence. Dr. Smith has to testify under oath, be subject to cross-examination. His credibility is tested. So the rules of evidence apply from day one until that jury renders a decision. Okay, what's the process? You start off, whoever is affected and wants to appeal files a notice of appeal within 60 days. The plaintiff files a complaint. Like any litigant, to commence an action, a complaint is filed, and the employer answers. All kinds of discovery tools in a piece of litigation, which are not available in the agency. Request for production of documents. requests for admissions, written interrogatories, oral interrogatories, depositions of lay witnesses. You can take discovery depositions of physicians. So the tools and the breadth of getting information are vast when you are in a trial court in a piece of litigation and the civil rules apply. Sometimes a claim has a defense to it. Maybe the claim was filed late. You got 2 years to file a claim. Maybe the medical evidence, even from the plaintiff's treating doctor, doesn't rise to the standard of proving a substantial aggravation of a pre-existing condition. Maybe the person was on some lark of their own when they got injured, wasn't in the course of the employment. Those types of legal issues don't have to wait for trial to be litigated. They can be raised and decided by the judge through filing motions to dismiss or motions for summary judgment. So you can put an end to litigation early if there is a legal defense that can be used in the court case and the judge agrees with your position. Physical and mental examinations are available under the civil rules. I've heard a lot of employers, well, we got a bad IME. We're in the agency, we get a bad IME. What can we do? And sometimes decisions are made not to appeal a claim to court because you got a bad IME. Just keep in mind, and every claim you got to analyze closely. Keep in mind that under the civil rules, an employer can get new IMEs. And generally, the courts, as long as the employer is willing to pay for the IME, a court is not going to deny that right, even if you obtained one in the agency. I've had many motions filed by plaintiff's counsel trying to deny us the right to get an IME. And their argument is, whoa, you can only get one IME on one issue. That is a commission rule. It has nothing to do with the court's proceeding. The trial court doesn't care, and there's no rule binding the court to one IME. You get 2 or 3 if you want. Point is, if you got a bad claim and you picked perhaps the wrong doctor to do the IME, or you didn't get it right, and the claim represents a big future exposure, the fact is, if you are in court, you have a second chance to get an IME that supports the company's position. And of course, it's a jury trial. 8 jurors, 6 of them have to agree, 3/4. Yes? Both parties waive a jury. It's very rare that the plaintiff, the claimant, will waive a jury, although it happens. It's a lot less time, obviously, without a jury, and less costly from a plaintiff's point of view, but 95% go to a jury. Yeah. Voluntary dismissal.
There's a question.
I'm sorry.
Yeah, I know that you said that the jury's not allowed to know the commission's decision, but does any of the evidence that's from the commission's file, medical report, any of that stuff, get activated?
Sometimes, but again, it's all testimony. It's not reports that come into evidence. Sometimes during a deposition, there's the IME report, and it'll have some reference to claim allowances on that report. And I've had judges redact all that. So there's ways to still get the evidence utilizing reports from the agency, but still not allowing the jury to know what happened. Yeah. Okay. Voluntary dismissal. Under the civil rules, the claimant has the right to voluntarily dismiss the complaint one time and then can refile in a year. It's called the saving statute. Prior to August 25th of 2006, even on an employer appeal from an adverse decision, the claimants had the right to voluntarily dismiss their complaint, and they could refile in 1 year. What does that do? It gives them 2 additional years of compensation. Because remember, if you have an allowed claim and it's appealed to the trial court, All forms of compensation, all forms of medical treatment continue to be paid with the exception of a PPD on the condition that is in court. So obviously the claimants were dismissing their complaints. Be malpractice not to. Effective August 25 of 06, 4123.512D was amended because of that reason, and now if it's the employer's appeal, the plaintiff no longer has the right to voluntarily dismiss. That case is going to get tried in about a year unless the employer consents to a dismissal. And very briefly, there's two cases. The 8th District Court of Appeals, the Ferguson case, has held that 4123.512 is unconstitutional because it upsets the balance between the judiciary and the legislature. The Ohio Supreme Court dictates civil rules, whereas the legislature enacts the Workers' Compact, and also that it deprived the claimant of due process and equal protection, I believe. That case is on appeal to the Ohio Supreme Court. The Dillard case, although they didn't decide the issue before them because it was not an appealable order, the Dillard case seems to support the fact that 4123.512 is constitutional and that an employer must consent to having their appeal voluntarily dismissed. So yet to be determined. I think the Supreme Court will take this case and we'll hear it. We have not seen claimants voluntarily dismissing their complaints in our employer appeals. So, what cases do you appeal? Where do you go with this? The whole point of managing and administering workers' compensation claims is to reduce and manage your future exposure, to eliminate reserves, to close down potential future liabilities. Uncertainty is not a good thing. This is probably the best way to achieve complete and final settlements of claims, is through the use of the 512 court appeal. And the reason is because up until this time, think about it. What investment, monetarily and time, has the plaintiff's attorney put into a claim through the agency? Their staff obtains a medical report from a chiropractor or attending physician. They get their file worked up by somebody in their office and they go over to a 10-minute hearing. And if they're successful, the money starts flowing. There's no investment. Once you're in court, usually from filing to trial, it's a year. All of a sudden, there's depositions, there's deadlines, there's pleadings that have to be filed, there's pretrials, there's final pretrials. All of a sudden, the time and the effort and the cost starts mounting. And it gives an employer significant leverage on those cases that you want to get rid of, that you want to eliminate that unknown future potential liability. That's probably the number one reason why you would appeal a given claim. Another factor is the person still employed. I mean, that's big. I mean, you usually don't settle claims with active employees. Usually when we settle a claim and you have an active employee, part of the settlement is a resignation. Does it make sense to settle a claim for somebody who has a degenerative disc disease in their lumbar spine and write a check for $25,000, and with or without a confidentiality agreement, it doesn't matter, and they report to work next week after the settlement and they cash the check, and they bend over to pick up a stool or a part, my back. They file a claim 2 weeks from now. You've accomplished nothing. So is the claimant an employee? Are there any issues pending in the agency? You know that Florence's claim? Allowed for lumbar strain, not a big deal. But she was on all kinds of medications, and she's got some serious emotional conditions, and she has filed a motion to include a substantial aggravation of a pre-existing anxiety disorder, and she's been terminated. She doesn't have a job. So the question on that claim, how do we manage this claim, could be a big ticket item down the road. but you've got an appealable order, the lumbar strain, that can force that claim into court because you know what's coming down the pike on that claim. So are there any issues pending in the agency, and do those issues potentially mean liability? And then there's always the issue of the impact on other employees. You know, if you've got a bad claim, or you've got somebody who's filed claims that had no substance to them, and people in the plant know who that person is, oftentimes an employer does itself well to challenge that claim and contest it, if for no other reason to let the other good employees who aren't taking advantage know that you're not going to get away with it. Messages are given in many different ways. Then you obviously have to assess what are the chances of success. You know, we've got this claim. So what types of things do you look at to determine whether this is one that we're going to take into the trial court? Well, what's the strength and weakness of the medical evidence? Who are the doctors? What have they said in reports? What do they know? Are there any legal defenses? Is the claimant credible? Is she or he believable? Has the description of the incident changed at all over the months or years? Are the person's complaints way out of whack from what all the doctors are finding on an objective clinical examination? Those are the types of things that can be developed in a trial court that cannot be developed in the agency. Credibility of the treating physicians. You know, most of these cases, it plays out the same way. Our IME doctor is given all of the medical information, all the prior histories, all of the current treatment records, and then they come up with an opinion. The treating doctor, number one, doesn't want to be bothered with all that. All the treating doctor wants to do is treat and submit fee bills. And so many times on these depositions, and Mark, I'm sure, can confirm this, the credibility of the treating physician and the believability of that treating physician's opinion on causation is subject to vigorous credibility attacks because most of the time they have not been given the hospital records or the prior doctor's records dealing with the same type of injury in the low back. So generally, if you pick the right IME doctor, your doctor should carry more weight than the treating physician. Depends on individuals. Then obviously the credibility of the employer's lay and medical witnesses, the identity of opposing counsel. Believe it or not, there's a lot of lawyers that are afraid to try a case. So you need to know the players in the game. And if you know that lawyer X is on this case and lawyer X has never tried a case or tried one 15 years ago, chances are that case is going to settle, and chances are it's going to settle for much less than what you had anticipated. On the other hand, if you get a lawyer who's a bulldog and enjoys being in court in front of a jury and knows the law and knows the medicine, you're in for a fight. And that case probably will settle, but it'll probably settle more at its true value than otherwise because of the identity and the competence and the just the makeup of opposing counsel. And then obviously the county in which the claim will be tried. If you're trying a case over in Cleveland, Cuyahoga County, it's a different type of environment than if you're trying one in Van Wert County. Some counties more conservative, some judges are more conservative. And even though the jury makes a decision, the particular judge has a tremendous impact and persuasion on how a case goes by virtue of his rulings. And then obviously you're looking at the claim. You know, what's the nature of the injury? Is it an injury that's going to require a lot of treatment in the future? Is it going to worsen? Is it a degenerative type of a condition? Or is it a one-time injury that's going to resolve and you're not going to have any more problems? Two totally different things. Any accrued periods of comp? What's the permanent partial award or the potential? You know, a lot of this is looking in the crystal ball and trying to make your best guesstimate as far as potential future exposure. But you've probably done that already because you've got reserves on that claim. And then obviously any potential for PTD. Well, how much education does the claimant have? What type of work has the claimant done? If you've got a 53-year-old person with a 9th grade education and all he's done is manual labor, and you're in court on a 3-level fusion in his low back, guess what? You've got a very real potential for a permanent total disability award on a 53-year-old person. The value of that case is large, any reserve would be large, and the whole point would try to be settling it to remove the reserve. Cost of litigation. Obviously, Mark and I, we don't do this for just jokes, although we like a lot of these cases we're involved in. We do get excited about it. So there's a cost of litigation. What are those costs? First of all, you got stenographic, videographic costs, depositions of lay witnesses, depositions of doctors, expert witness fees. So you have 2 IME doctors and you have to take their depositions, trial depositions, usually a month or so before trial. So they charge a fee. Fees are all over the board. And you also videotape them so they can be shown. So that's a cost. If you lose in the trial court, there's a statutory attorney fee. If the claimant is successful, that's $4,200 currently. And then there's the defense attorney fees, our fees. I just wanted to let you know that the journey in a trial court lasts about a year, maybe a little longer. And the costs in a piece of court litigation are backloaded. And what I mean by that is, until you get to about 2 to 3 months before trial, the majority of the attorney time and the majority of the costs are not incurred. It's only once you pass the final settlement conference and the mediation date that you know this thing's going to go, that you start lining up your medical doctors. And many, many cases settle before you ever get to that 2 to 3 month time frame before trial. And then state fund employers, I'm sure we have state fund employers here. Same types of analysis. You get your actuarial analysis as to what this settlement will cost in future premiums. How old is the claim? After a certain period, the claim passes out of the employer's experience period, has no impact on the employer, whatever monies are paid. What's the maximum claim cost for a state fund employer? Once you exceed the maximum claim cost, any additional dollars paid in that claim will not do any more damage to the employer. It's capped. Does an allowance of this claim jeopardize the employer's ability to enter into a group for rating purposes? Not so much anymore, but there was a period of time when we were getting a lot of state fund employers taking cases to court because they were fearful, and rightly so, of being thrown out of a group or not being able to get into a group because of this one claim. And so that's an important consideration for a state fund employer. And also, if you're successful in court, obviously, there's overpayments and credits to your experience. And now, Mark's going to talk about the other story.
Okay, so not to waste any time, mandamus. A writ of mandamus is basically a command to an agency to perform its duty. Mandamus is it's a Latin word, and the pronunciation is mandamus. I've heard it pronounced a lot of different ways. This might not be the proper Latin definition, but it is how we English-speaking people pronounce it. And basically what you're doing on mandamus is telling that agency, by way of your writ, your petition, your complaint, you're telling the court that they messed up. And because they messed up, you want a higher tribunal, a court, to tell them to do what they're supposed to do. So it is different than trial cases, okay? where you have a jury, where you have a judge kind of monitoring the proceedings. This is a totally, I like to call them error proceedings. They're sort of like an error proceeding because you're looking to see what they did wrong, what mistakes there were. But it's a totally different process. And I think it was Dave, you must have asked Greg about the evidence in a common pleas court trial. And just so that there's no confusion, a lot of the evidence that you have in the agency, you can use it in a trial court when you're going to a trial. But the thing is, it has to conform to the rules of evidence. So like the IME reports, the rules of evidence wouldn't allow the IME reports in, okay? But a lot of your doctor's reports, your hospital records, things of that nature, as long as they've been properly authenticated and somebody's gone through the rigmarole that's required under the rules of evidence, then those things can come into evidence. But it's not an equal equation. Everything that's in the agency is going to end up in court. That's not the case. Now, where mandamus is concerned, as I said, it's not an appeal. You might want to think of it as an appeal because you're going to another place, but it is not an appeal. And in this context, Greg told you that 512 appeals are de novo, which means that everything that happened in the agency is meaningless once you get into court. You start all over with your evidence and everything. On mandamus, not the case. These things get filed in three places. Either the Common Pleas Court in Franklin County, which nobody does, the Court of Appeals, which I already told you about, the 10th District Court of Appeals, or the Supreme Court of Ohio. You can file a mandamus action in any one of those three places. The Supreme Court and the Court of Appeals have original jurisdiction over mandamus actions. Most people go directly to the Court of Appeals. And they like to do that because why take 3 steps when you can take 1 or 2? Most people won't go directly to the Ohio Supreme Court because it's kind of risky. They kind of like to try their luck out before the Court of Appeals. But why start at the Common Pleas Court where you're going to have to go through this process 3 times? No one would do that, okay? It's always in Columbus. Does anybody know why mandamus is always in Columbus? Besides Janelle? Anybody have any clue? Want to hazard a guess? Where is the Industrial Commission? Where's the administrator of the Bureau of Workers' Compensation? Where's that office? Columbus. So when you're asking the administrative agency to do its job, okay, the principal place of business of the Industrial Commission and the Bureau of Workers' Compensation is Columbus. That's where you're going to have your mandamus action. That's where venue is proper. So we talked about this concept, extended disability. It is really, it's a term of art, okay? It doesn't mean anything. It means anything and nothing. Extended disability, for your purposes, is compensation issues and medical issues. That's really all it is, okay? It's not an allowance issue. It's just compensation and medical. So if you have a treatment issue on a C9 that you're challenging, it's TTD, permanent partial disability, permanent total, mandamus. That's extended disability. I say it's a term of art because the concept of extended disability will come up in 512 appeals. And lawyers on the other side like to say, oh, we don't have any extended disability issues here. When you're trying a case in the trial court, a lot of times you formulate your defense based on how somebody recovers, okay? It doesn't make sense if he has a herniated disc. Well, let's say it doesn't make sense if he has a lumbar strain to be on disability or disabled for 2 years and to be taking narcotic pain medication for 2 years. So you're going to be arguing about the extent and the nature of this guy's disability, but that's not an extended disability issue. And that's why I say it's really just a term of art. Mandamus is only for those decisions that do not finalize the allowance of the claim, okay? Decisions that finalize the allowance or the disallowance that finally cut a claim off, those are right to participate issues. And this is when the whole process gets confusing, because out of one order, okay, depending on which side of the coin you're on, whether you're the employer or the claimant, and how it comes out, you could have both a trial court issue, a right to participate issue, and a mandamus issue, depending on how that decision is rendered. So, employers in the room, I know that you have a lot more than just simply claims that you deal with. Here are some other examples, just so that you're aware of it, and we are getting a little tight for time. The Commission's continuing jurisdiction, whether or not they properly extended that, that would be a mandamus issue. Nothing to do with the right to participate or an allowance issue. Your self-insured complaints, if you're self-insured employers, and you get a self-insured complaint, and you go through the Bureau's procedures on that, you don't like the outcome, it's a mandamus issue. Same thing with VSSRs. If you're state fund, and it's a premium issue, again, there is no right to appeal a premium issue to the trial courts. That's not set out in the statute. You have to take it mandamus. So, as we said, the procedure is different. Greg told you there's a 60-day appeal period in trial court, in courts of common pleas. There's no filing deadline on mandamus. You can wait almost, I say almost, forever. I mean, there's really only one concept that prevents you from waiting until, you know, you get old and gray, and that's the concept of laches. And it's just simply a legal concept that means you can't wait forever, not to the prejudice of the other side. But, you know, is it 5 years that you have to file this? Is it 7 years, 10 years? Really depends. You should make your decisions relatively quickly, but you don't have a time frame in which to do it. The standard in mandamus is abuse of discretion, okay? Now, Greg told you that when you go up in a trial court situation, you've got all your evidence, it's de novo, you go before the jury, and you're putting on a presentation to them, you know, does this person have the right to participate? Mandamus, like I said, it's an error proceeding. You're telling this court that that agency screwed up. So the standard that's used is abuse of discretion. It means two things. If they rendered a decision that's contrary to law, that's an abuse of discretion. If the decision on an extent of disability issue is not supported by some evidence, then it's an abuse of discretion. Because the way the courts have looked at this, most times on extended disability, you're looking at stipulated evidence. The evidence is already there for you, okay? And the court doesn't take any new evidence. So they're looking at the evidence and say, well, did the commission have enough to do the right thing? Did they have enough evidence there? If they didn't, it's an abuse. If they did, then the court is going to defer to the Industrial Commission. And they use magistrates to make the decisions initially once you're on mandamus in the Court of Appeals, which is an unusual procedure. These are your two magistrates. They don't wear spacesuits, okay? But we have this space concept, and sometimes their decisions are kind of spacey. You only have two magistrates, for the most part, that decide workers' comp matters in Columbus. It's Magistrate Mackey, is the gentleman on the left, and Magistrate Bisca-Brooks on the right. Collectively, they have got 70 years of experience in workers' comp issues. They know more than the Court of Appeals does, okay? You file briefs on mandamus. You're not bringing in witnesses. The evidence is established. All you do is write briefs to the court, and then you have an oral argument before those two magistrates. It's very rare that you go beyond those magistrates. And then if you don't like the decision of the magistrates, you can object, and from there you go to the Court of Appeals. Now, in the 10th District, you've got 8 judges on the Court of Appeals. I show them to you for one reason, to show you that this court is fairly diverse and that the decisions coming out of the Court of Appeals are not always consistent. 4 of these judges have got 10 or more years of experience on the Court of Appeals. 4 of these judges have only got 4 years or less. So it's not always consistent what decision you're going to make. And as I said, the magistrates actually have a greater body of knowledge than the Court of Appeals does, but there are only a pool of 8 judges that are going to be deciding your mandamus issues, and 3 of them get assigned to a case. And ultimately, you get to appeal a mandamus action to the Supreme Court. Now, I'm going to pass it on to Greg because we've got about 5 minutes left. So we need to tell you how these fact patterns apply.
Okay, the question with Fred is whether or not the commission's order abating the claim and finding pre-injury status is appealable. And I think there might be some disagreement in the office, but I'll give you my take on it. If the commission finds that Fred has reached pre-injury status with his pre-existing condition, that claim will be abated for that particular condition, and Fred will not be able to receive compensation or any medical treatment or benefits for that condition. In essence, the commission will have terminated his right to participate for that condition. It is appealable. And my opinion is confirmed by the Clendenin decision that we cite there. Flip it over. Suppose they deny Ohio Trash's motion. They say, well, you know, we don't think that Fred has quite reached pre-injury status, so we're going to deny your motion. My take, and there's no case law on this, but if you've read enough cases over enough years, in my opinion, is that is not an appealable order because it doesn't terminate his right to participate. He can continue to participate for that condition. It doesn't allow any additional condition. It is purely an extended disability issue. You can challenge it by mandamus through the route that Mark just said, but you can't appeal an adverse decision on that motion in Fred's case. Anything to add?
Well, Greg is probably right. The courts have not decided that specific issue, but they have discussed the issue in other contexts. And when in doubt, file your appeal in court. The reason you would do that is if you don't appeal to court, you've lost that right. And you don't know how a trial judge or a court of appeals is going to decide it. But more than likely, that decision is one that goes mandamus because it does not finalize the compensation in the claim. It doesn't foreclose the claim.
An very important point that Mark might, if everybody picked up on it. If there is a question whether or not the order is appealable under 512 or not, appeal. Because if you fail to appeal and you go mandamus, a defense to that mandamus action was you had an adequate remedy at law. You had an appeal under 512. And if in fact the Court of Appeals down in Franklin County says, yes, you did, you're basically out of luck because you're not going to get a decision in mandamus, and chances are you waited more than 60 days to file the notice of appeal from the order. So when in doubt on the appealability of an order, appeal it. Florence, this claim probably, and I think I mentioned it, you had an initial allowance for a lumbar sprain, and you see what's coming down the pike on the anxiety disorder. And she's not working, and she was terminated for excessive drug use, prescription drug use. And my sources tell me that it's just going to be problematic from a psychiatric, emotional point of view in this claim. The recommendation would be to appeal the lumbar strain to court. You'd have a defense, perhaps, that she was under the influence and ran into the car, which would be a total defense to the claim. But more importantly, you have the claim in court on the lumbar strain, and even though it hasn't cost much money yet, you see what's coming. And if you can stop the claim within its first 9 months or year, perhaps win the lumbar strain or settle it, you're not waiting for 3 or 4 years and waiting to appeal the generalized anxiety disorder to court after she's been paid a year or two. And remember, If, in fact, you can get it into court, the leverage applied on that case is tremendous, and it's going to be a problematic claim. It's going to be a big-ticket item, and the sooner the better that you can put the leverage on plaintiff and plaintiff's attorney to reach some final resolution of a potentially bad claim. You have anything else?
No, just to say that claimants' lawyers tend to stack their allowances, okay? You won't see all the allowances when the claim is first filed. So as you're managing a claim and looking at the claim to determine, oh, do I want to appeal this or not? If it's a simple lumbar strain, but you see in the medical that this person's had pre-existing problems, you see that the doctors are actually diagnosing aggravation conditions, even though no one's moved for them, you know it's coming down the pike. And that's when you want to get control over early. You don't want to say, well, it's just a strain now. Well, it is a strain now, but it can balloon.
Right. What about Archie? What about Archie? We've talked enough about Archie. You have anything?
Well, just to say that, as we said, and we are near the end of our time, or at the end of our time, Fred, Archie, Florence, you're looking at the compensation issues. You remember Archie was one that was statutorily PTD. Most people think that's the holy grail, that's the end of the claim. But as Rob King explained, there's a possibility that with a statutory PTD, that person can go back to work. They can have like an infection or an additional surgery, which might result in temporary total disability compensation or additional medical benefits. As an administrator of workers' comp, you think that you're done with the claim or you want to be done, but you're not. Those issues are ones that you may want to mandamus. The reason you want to mandamus it is because, as Greg said, court puts pressure on people, puts pressure on the claimant and their counsel, because these are specific kind of procedures. It can help you to get that claim ultimately settled, and you can avoid the future liability in the claim. Florence, she has the issue with the psych issue. The, what is it?
Pre-existing generalized anxiety.
She had the anxiety disorder. Tybo talked to you about termination issues. This came up in a conversation with a client the other day. If you recall the fact pattern, Florence had prescribed methadone in her system, okay? Under point 54 of the statute. If the methadone was the cause of the injury, it's not compensable. That's a trial issue. That's a trial defense. However, as far as whether or not your termination of her, because having these drugs in her system violates a workplace rule, okay, that would go to compensation. So let's say her claim's allowed, and you want to say, well, you know what, we terminated her because she violated that work rule due to having these drugs in her system, and we have a work rule against that. That's a mandamus issue, one that you want to be careful about, because in past seminars we've talked about the Gross case. It's the Kentucky Fried Chicken case, and it stands for the proposition that if an injury and a termination occur at or around the same time, the courts are going to look at it with some scrutiny. Because using voluntary abandonment as a defense to compensation, what the courts have said is generally that applies to terminations that occur, that do not occur at the time of injury or before the injury. Okay? So here you have a situation where the termination is more or less, and the terminable offense is contemporaneous with the injury. A court might look at it with some skepticism, but if the basis for terminating her is violation of that policy, there's a good chance you might fall outside of gross and term the compensation.
Okay. I'm just going through this.
Yeah.
We've probably talked about it. Well, what are the takeaways here? Very simple. Court remedies are given to employers and claimants by the workers' compensation statute. They are tools to use in the administration and management of the claims that you believe need that type of management. To not use them is, quite frankly, not doing as good a job as you can. Utilize them early. If you decide it's a claim that needs attention and it needs to be contested and there is a significant future exposure or whatever the reason, the earlier in the process, the better. Once the horse is out of the barn, it's hard to rein them in. Got to go through that cost benefit, every claim. And again, an integral part of claims management. So I think that's it. Any questions by anybody about anything? Okay.
Question over here.
I just want to comment, as a TPA for state fund employers, the maximum value can change over time. As the employer's payroll gets bigger,
Right.
that maximum value can increase. But just because it's 12,005 today doesn't mean it won't be more in 2 years.
And it would be increased on a particular claim? Or does it stay the same on a claim?
No, it's based on the employer's experience in one particular year. So this year, the maximum value might be 12,500, but 2 years from now, if it's a new employer
Yeah.
and they don't have much payroll, their maximum value is going to be smaller.
Okay.
But as they grow and have 4 years of payroll or whatever, that maximum value can increase. So be careful when you're settling claims to keep in mind what those limits are.
Right.
Because you can settle it for too much.
Okay, and again, I'm not an actuary. I've talked with many actuaries, but what you're saying is if the maximum claim value goes up because of the payroll of the employer, even though you have a claim in 2 years ago, that new maximum value is transferred to that 2-year-old claim, and it constantly changes. Okay, thanks. That's helpful. Anything else? Okay, I guess it's drawing time,
Drawing
isn't it?
time.